Hello, happy Friday. Happy Friday, everyone. I'm just going to wait for you guys to tune in. If this is your first time, definitely say hi in the comments. Let me know where you're tuning in from. Even if this is not your first time, say hi in the comments and let us know where you're tuning in from. Just going to wait for y'all to waltz in. Good morning, Facebook, or good afternoon, Facebook. Good afternoon, Instagram. Good afternoon, YouTube. Hey, Nikia from Queens. How are you? Happy Friday. Um, Good afternoon, Minaj. Good afternoon, Word from Jamaica. One of my favorite places to be. Um, Hi, Sheep Hattie from Brooklyn, New York. The BK and MST from the Boogie Down Bronx. Hello. Life Change says, when someone books with you, will they be working with you or someone else on the team? Our law firm, we work together as a team, meaning that we all work together to deliver the best product for our clients. And ultimately, I have the final say, the final revision, the final check mark before we submit it. So even if you have, one of our staff collecting documents and stuff like that, we all work as a team and a very capable team. And then once everything is finalized, I do the final seal before we send it out. So don't worry, you will still get me. Um, Ademi says, "Hi, my first time. I'm calling from Minneapolis. Thank you. Welcome. Hi, Boo for the Boolas. Okay, so let me introduce myself. My name is Ayesha Chidole. I'm an immigration attorney and I represent clients in all 50 states in the United States. Personally, I'm located in Atlanta, Georgia. We've got an office in Florida as well. But your location doesn't matter. Immigration is a federal law, so we take clients all over. Let me pin my phone number on Instagram. So phone number is not 407-995-6567. Or you can also send us a WhatsApp. And the WhatsApp is 404 8751. All right, guys, give me a second to just pin this number because I know you guys like me to pin it. And then I'm a pin pro. Today, I want to talk about a topic that I get asked about and confuses a lot of people as far as what path they should take, what are their options, and stuff like that. So let me first start by breaking down essentially what is a 90-day fiance. What I'm sure you guys watch the show 90-Day Fiance, or you hear about it. If you've not watched it, you should watch it. It's very entertaining. But basically, 90-Day Fiance just essentially means a fiance visa, okay? And it's also known as a K1 visa. And the process and how it works is slightly different from a spousal visa, which is a visa that basically gives you a green card when you enter into the United States. And as soon as you enter into the United States, you're automatically a green card holder. Thank you so much, Boo for the Boo List. You can ask your question. With a fiance visa, some of the requirements, one, are that in order for you to petition for somebody outside of the United States as your fiance, you must have met the person. You must have met the person at least once in the last 2 years. This is really critical. People could have gotten away with it, like, maybe in 2020, where you're like, oh, COVID, bans and all of this stuff. Right now, travel is not as restricted in many, many, many countries. Obviously you have to follow the requirements, but it's not really restricted where you can really use that as an excuse. So generally, unless there's something that makes it extraordinarily difficult for you guys to meet, you can file for so you have to meet that person. You have to physically see the person, whether it's in their home country or whether you guys decide, okay, we're going to meet somewhere else. So that's number one. Number two, you must be a US citizen. As a green card holder, you cannot file a fiance visa for somebody else. You must be a US citizen. Now, um you also have to make sure that you meet the income requirements. As you guys may know or may not know, income is determined by how many people you have in your family. So when somebody says, oh, well, what is the income requirement? I can't tell you what the income requirement is because I don't know how many people are in your family. If I know how many people you claim in your taxes, then I will be able to say, okay, this is the income requirements, this is the poverty guidelines on what you have to meet. And then while that is lower than a normal marriage-based case, keep in mind that once the person gets here, you then have to show that you meet the income requirement for a marriage-based case. And if you don't meet the income requirements, also know that you can use a joint sponsor to petition for somebody, and that joint sponsor obviously has to be in status as well. Has to be a U.S. citizen or a 10-year green card holder. Okay. So that's first and foremost. And then, of course, you have to prove, just like with marriage, that you have to prove that you have a bona fide marriage. You also have to prove that you have a bona fide relationship, with the fiance visa. A lot of times, if you don't live together, you're not going to have like, proof that you live together or utility bills or bank statements and stuff like that. But it's always a good idea to document stuff if you send things to each other. Like if you send money to your fiance, or your fiance sends money to you, it's always good to make sure that you keep that, because those are things that you can use as evidence. Also, a personal statement of your relationship and significant things that you did and saw when you were around each other is also very helpful. Affidavits are also very helpful. If you guys use like calling cards, now in a lot of these calling cards, you can do them on your phone, like RebTel, or what's the other one called, VIP, and all of this phone, calling cards that you used to call internationally. You can use your call records to show that you're talking to this person all the time. The same goes for if you're communicating on WhatsApp or if you're communicating on Instagram. I think Instagram has a call like feature. Document all those things. And stuff like that. So, and then also for your fiance that's outside of the country, it's really important that they know you as their fiance. Meaning, if you have children, they should know your children. They should know your children's name. They should know basically everything that you fill out in the forms. They should be able to answer those questions, because sometimes they ask them those questions and sometimes they deny them on that basis, saying, well, it doesn't seem that you guys have a legitimate relationship. Okay, so let me fast forward to, let's just say everything goes well and you basically get the fiance visa approved. Once you get that fiance visa approved and you enter into the United States, you now have 90 days to marry your spouse, your fiance. And that is why it is called the 90-day visa, or the 90-day fiance, the show, or whatever. That's essentially why. In that 90 days, you want to get married and also then start your adjustment of status application only. So, it exempts you from doing an I-130. So you're still going to have to do the adjustment of status. It's not the same thing as if your consular process, once you enter in here, you're done, but it's different. In this one, that you now have to apply for your adjustment of status. Now, if you do not get married within that timeline, you're going to have to start your whole process all over again. Meaning you're going to have to fill out an I-130, you're going to have to prove bona fides again, and all of that good stuff. So it makes the process longer. So you want to do that. The second thing, and this is where people get caught up, that I need to make sure you guys understand today. If you don't understand anything else I've said, pay attention. If you come here on a fiance visa, you cannot marry somebody else and expect that person to adjust your status. The person that petitioned for you, you must marry that person if you want a green card. If you don't want a green card, then whatever. If you want your green card, you must marry that person. If you enter here on a K1 visa and you go marry somebody else, the only way you can get your green card is through a waiver of hardship, and then you got to leave the country. You got to leave. So, and then if you leave, you of course deal with a risk of whether or not you'll be able to come back or not. So it's really critical. Obviously, one of the reasons why they're doing this is to make sure that U.S. citizens don't become victims of people who are just trying to get into the United States. So they want to make sure that these relationships are legit. So keep that in mind, because I can't tell you how many people say, oh, well, I married somebody else because things weren't working out. Can I get my green card? They're US citizens. And I'm like, not without you leaving the country. Not without you leaving the country. So note that. So that's really all there is to a fiance visa. Um, it's annoying because obviously, you have to do two processes, but oftentimes it's quicker than consular processing. Before it used to be significantly quicker than consular processing. Now it is not as significantly quicker. It's still quicker, but there's just so much backlog. There's still some time that it takes, so it's still quicker. So when you're trying to decide, for you and your family, should we consular process? Should we do a fiance visa? You want to take all those things into consideration. Like I always say to people, is it important that your spouse is here the soonest? Or is it important that once your spouse comes here, they're able to hit the ground running, start working? If they're one of the people, if let's say your spouse is someone who takes care of their family back home, like their parents or siblings, is it going to cause marriage conflicts if your spouse is here for another 8 to 10 months without working? Are you going to be able to support that person? And I know you guys would probably not necessarily think about that, but I can't tell you how many marriages, or clients who come to us and things are wonderful. And once they come here, things change. And, it really pains me, my clients will tell you, I'm very invested in my clients and making sure their marriages work, especially the ones who are doing like marriage-based case. And I have had to play therapist many times, for clients to just bring them back to Jesus and let's work this out. But marriage in its first year is very difficult for a lot of people. Anyone married will tell you that, merging two families or two grown adults together, especially when you have two different cultures, it's an adjustment. So if adding a financial burden becomes an additional adjustment, you definitely want to evaluate whether a spousal visa might be better, because if that's something that will elevate some of the conflict, then you should definitely consider that. Okay. All right. Let's see some questions. Good afternoon, Brandon. Happy Friday. How are you? Good afternoon, Vernice. Latoya Gordon says, how long does a vow case take to process? Most vow cases take about 22 years to 2.5 years. I mean, you're always going to have some exemptions or exceptions. Some cases end up getting done in like 18 months. I mean, we've even had some, in less time, but it's really extraordinary. There's usually something that we can use to explain anything less than 18 years. So it's really not the norm. So, and that's why if you qualify for adjustment of status, you should be applying for adjustment of status with your VAWA application. So you can get a 2-year green card and a 2-year, not 2-year green card, a 2-year work permit and a 2-year travel permit. So that way, you can at least be working. And if you need to travel outside the country, you can do that while you're waiting for the process. Okay. Latoya says, Ayesha, how are you doing? The best lawyer. Thank you so much. I'm doing good. So Cydia says, good afternoon. Thanks for all your information. I have a question. I have advanced parole. My mom died, but I'm afraid to go to the funeral in Jamaica. I'm scared that they won't let me back in. I need your advice. Cydia, you can definitely call our office so we can make sure that you don't have anything that might affect you from traveling. Like I've always said, with traveling, it just depends on what stage in your immigration process you are, what types of petitions you filed before to determine whether traveling is going to put you at risk. Generally, if there's absolutely nothing in your records, you've never applied for asylum, you've never been in removal proceedings, you're not doing this post-interview, then sure, travel for your mom's funeral. And I'm sorry about that. But without knowing you personally and your immigration history personally, it's hard to say whether you can or you can't. Alex on Facebook says, any similarities or differences between VAWA 485 and marriage-based interviews? Yes, they're very different. A marriage-based interview is an interview where they're checking to make sure that you have a good faith marriage and your marriage is legitimate and bona fide. By the time you get to a VAWA interview, you've already been approved for VAWA. And in order for you to be approved for VAWA, they've already established that you have a good faith bona fide marriage. They've also already established that you've been abused and that you're a person of good moral character. Now, when you get to the interview for 485s, the focus now is going to be on your form. Exactly that. Your form, making sure that everything on your form looks okay. Like if there are any new crimes that you don't know about, they're amending. Anything else, if you've ever claimed to be a citizen, I'm just listing some random things. You should never list you're a citizen if you're not a U.S. citizen, because that is a bar with no exemption, other than if you qualify for a U visa and stuff like that. But so they will be looking at things like that just to make sure. It's really critical also in any interview you go to. This is not just only VAWA, but I'll speak specifically about VAWA in a second. That all the information like addresses, dates of divorces, and dates of marriages. Okay, a lot of victims black out. When you've been a victim of something, part of post-traumatic stress is you blacking out and forgetting things that make you remember a painful time in your life. And I know that happens and it's unfortunate. However, when you go to this 485 interviews, you must refresh your memories. I know it's tough, but you must refresh your memory on dates. So you want to know your address history. You want to know when you married that person. You want to know when you divorced that person. You want to know when you moved from house A to house B. Dates and addresses. Those are really critical. You want to make sure if you're divorced from your abusive spouse that you bring your divorce decree. Basically, any change that's critical for USCIS to know, you want to make sure that you present, because 2 years, a lot can happen in 2 years. So if you were still married in 2 years, and by the time you're going to your interview, you're divorced, it's really critical. You're going to your interview, it's really critical that you bring your divorce certificate. If not, they'll give you an RFA to bring it. So it's more laid back. That's a valid interview. That being said, you still have to know all these things and make sure that you don't have any crimes of moral turpitude or anything that makes you inadmissible. Okay? All right, let me take some on Instagram. Even Saka says, this lawyer is so good. You really know how to communicate with your folks. Thank you so much. I appreciate that. Bean Princess says, hello, hi. Olamidia Day says, hi there. For a green card holder, what options are available to bring a fiance? None. You cannot bring a fiance as a green card holder, unfortunately. The only way you can bring your fiance here is if you become a U.S. citizen. Okay. So a friend came into the U.S. with a fiance visa. They've been married over 2 years here in the U.S. They got something, and the wife kicked him out, and he left the house to meet another woman and got her pregnant, and he separated from his wife. He just got the 2-year green card. So what is your question? What is the question you're asking me? Okay. Is it normal for USCIS not to send a receipt after 3 months? None, I haven't received my receipt. Well, it depends on what your case is. So if you let me know what case it is, then I will be able to tell you what we see. Tala says, thank you for what you do. Keep these lives and videos coming. Very helpful. Thank you. You're welcome. If you get divorced while waiting for your I-751 conditional removal, basically you're trying to say if you get divorced while your I-751 conditional removal is pending, how does that affect you? So it does affect you. So this is very critical. And so if you're in this situation, listen and listen close. In order to remove the conditions on your green card, you must file jointly. The only way you can get your removal of conditions removed if you're divorced is you must request an exemption. So in your case, if you are divorced, you must amend your petition. You must amend your petition and request an exemption based on a waiver of divorce. Now, even if you're divorced, they still need you to prove you had a bona fide legitimate marriage. A lot of the proof that they're going to want to see is not things that you submitted when you got your green card. It's going to be things that you acquired and had after you got your green card. That is where the core focus of evidence is. But you can't just get a joint, submit the joint and not notify and let them know that you've got the divorce, unless, you were doing it by yourself, because you need the exemption. Because if not, it can affect you during citizenship. Okay, let's see. Okay, so Cydia on YouTube says, I'm on a vow petition now. Got my prima facie letter. Good for you. But the thing is, I came on a visiting visa. I fell in love, got married, and I had to go back home to sort out some stuff for my 14-year-old. If we apply for I-360 and 485 at the same time, and if the I-360 is denied and we're out of status, do we get an NTA? Call me and schedule a consultation, Cydia, so I can really understand what exactly is going on with you. Okay. Stephen Miller says, once you notify USCIS with a change of address, will they notify you back that they received your notice? It depends on what kind of case you have. If you're doing a regular marriage-based case, and you do it online, yes, you will get an email saying that we've updated your changes. If it's a manual entry, like if you're an abuse victim, you can't do it online. The only way you can enter a change of address is through mailing it, or through your attorney mailing it. With that, generally you're not going to receive an acknowledgement. Okay. Okay, let's see what else. Oh my god, my phone is ringing off the chain today. Let's see. Okay, so this person says, for a green card holder, what options are available to bring in a fiance? What happens if she comes in on a visit? Can we adjust her here? So again, if you're a green card holder and your fiance is outside of the United States, you don't have any option. However, if your fiance comes into the United States and you become married, like meaning you marry the person, you can then do an adjustment of status if visas are available. The answer will depend on the month that this happens. The visa availability changes every single month. So this month, visas are available, right? We don't know. They've not received. They've not posted the July bulletin, so we don't know what's going to happen in the July bulletins. We don't know what's going to happen in August. So it just depends. But let's assume that you wanted to submit it this June. So technically, if your spouse was here and you're a green card holder and her entry was still valid, there's a difference between how long you have your visa before it expires, and how long your I-94 stamp is. Because you can have a 10-year visa. It doesn't mean you have 10 years in the US. What is written on your I-94, how long can you stay in the United States on this particular visit, is what you use to determine status. If the person comes in and they get let's say they get a 6-month stamp, and you submit the petition within the 6 months while they're still active in status, as of this month of June, you can technically do that. A few caveats. If somebody comes into the United States and you go marrying the person or filing an adjustment of status within 90 days of them being here, there is a presumption of misrepresentation and willful misrepresentation. What that means is that you actually intended to do that, but lied to Customs and Border or lied. So it's generally better that these things are done after the 90-day window, because after the 90-day window, then they're just focusing on, is your relationship bona fide? Is this person eligible? Trust me, you don't want to add misrepresentation as another ground for them to evaluate you on. So I hope you understand that. Okay, guys, I have about 10 more minutes and then I've got to jump off. Let's see. Somebody asked, can I get a state ID with an I-130 approval letter? Not that I know of. And every state has separate rules for their DMV. Personally, I don't know of any particular states that allow that. However, You can go on the DMV website of your state, and usually it will list what documentation is required to get a driver's license or a state ID. It's very, very simple. Go on DMV Georgia, DMV New York, whatever state you're in, just ask for and then search for document requirements to get a driver's license or ID, and usually it will tell that to you. Okay. Okay. Um, so Tyler says, does a stepchild age 21 being abused by the stepmom, can they file for VAWA? So this is actually a very good question. I don't talk about it often, but this also happens. So it's really important to mention that children also qualify for VAWA, whether it's by their parents or by their step parents. So if a child is being abused by their parent or stepmother or stepfather, they qualify to petition for VAWA by themselves, without their parents, by themselves. If typically the child must submit their petition before they turn 21. Okay. Now, apart from that, there will always be a category of there are a category of people where they will allow you to submit what we call a late submission between the ages of 21 to 24, because once you hit 25, it's done. You can't. So between 21 to 24, you can submit if you're able to explain that part of the reason for the lateness of submission is also due to the abuse that you face. The difference here, though, is that if you do it after the age of 21, you cannot apply for adjustment of status while your case is pending. You have to wait till your VAWA gets approved 2 years later before you do that. So because once you hit 21, you're no more an immediate family. You're now in the family preference category. So you gotta wait till then. Okay. And Home Summer says, I've been married for 3 years. Went on my interview, did the fingerprints, got the petition approved, but still didn't get a social or work permit. So if you were approved for a green card after your interview, you're not going to get a work permit. Your green card becomes your work permit. Your green card basically allows you to live freely in the United States. If you didn't get a social security number, it's probably because, as you said, you didn't get your work permit, because that usually comes after the work permit approval. What you can do is just go to the Social Security office in your locality and apply for one. And usually, if there's one that has already been issued out to you, they'll let you know. If not, you can just get a new one. Okay. Let's see. And then McDaniel says, I've been married to a green card holder in the US and we already have a child together. Can she file adjustment of status for me? McDaniel, if you are in the United States and she's a green card holder and you've stayed in this country with your visa, with your entry for more than 6 months, no, she cannot file for you because you're not eligible to adjust your status. All she can file is an I-130, which just allows her to prove that she is your spouse. And then once the I-130 gets approved, then you can submit a 601A waiver, which is a hardship waiver, saying that your wife is going to have hardship if they don't allow you to stay in the country. If that is approved, then, once it's approved and they schedule you for your interview back in your home country, you can go for your interview back in your home country, barring no other reasons why you wouldn't qualify, and then you can come back into the United States. If you are submitting a 601 waiver, you need to understand that not just anyone can submit a 601A waiver. You have to have a qualifying relative. For a marriage-based case, or just, a normal adjustment of status, not adjustment of status, like normal green card application, like family basis or whatever, your qualifying relatives are your parents who are U.S. citizens or green card holders, or your spouses who are U.S. citizens or green card holders. Your children are not your qualifying relative, even if all your children are U.S. citizens. I mean, you can add it to show hardship to your spouse, to say that leaving your spouse and her having to raise all the kids, it's going to be a lot, and how that can affect her, emotionally or financially and stuff. But the person they're focused on is your spouse or your parent. Okay. And this is going to be the last question I take, and then I got to jump off. Sasha says, I filed a vow petition and I did a fingerprint and all, but my husband died last August. What's going to happen? That doesn't affect your petition since you filed it before your husband passed away. So your petition will still go as, normal. If let's say you filed it more than 2 years after he passed away, then that would be a potential issue. Anyway, guys, I gotta jump off. I hope you guys have a wonderful Friday. Again, if you want to schedule a consult, call our office. It's 407-995-6567. You can also send a WhatsApp to 404-333-8751. It will be in my profile on Instagram if you don't catch it on the pinned post. Also, you can see it scrolling through the ticker on YouTube and Facebook. Again, it's also going to be in my profile. And if I didn't get to your question, call me, schedule a consult. Guys, I talk about this all the time. Like, if you want personalized information as it relates to you and you want to get all your questions answered, just schedule a consult so you can, really dig in and know what you qualify for. I'll be back on live on Tuesday at 10 o'clock. So until then, I hope you guys have a wonderful weekend and talk to you guys later. Bye.